Okay, it's 1 o'clock. Or should I say 5 now. The show is what's going on. I'm your host, Hugo Fernandez here on the radio, WLGR. And thought I'd start the show with one of my favorite George Harrison songs. Kind of a fun video there, which I think is apropos to today's show. What is life? When does life begin? Which ties into what we're going to be hearing the recordings from May Please the Court, arguments on abortion, here Webster versus Reproductive Health Services in Missouri. And my guests today to talk about this are going to be Dr. Vera Albrecht and Dr. Shannon Proctor. Say hello, ladies. You're both muted. They're muted now because they know that we're now going to cut to the recording of the oral arguments. This is the Rehnquist Court for the next 20 minutes with our engineer, Mr. Pope, behind the scenes, pressing the buttons for PowerPoint. So let's listen to the case. We'll be back with commentary.
Arguments on Abortion presents the case of Webster versus Reproductive Health Services. The edited arguments are narrated by Professor Peter Irons of the University of California, San Diego.
We'll hear argument now in number 88605, William L. Webster versus Reproductive Health Services. General Webster.
It's Wednesday morning, April 26, 1989. Chief Justice William Rehnquist has called for argument a case that opens for reconsideration and possible reversal, the historic decision in Roe v. Wade. Ever since the Supreme Court decided in 1973 that states could not make abortion a criminal offense, abortion has become the most divisive political issue in America. Over the past 15 years, the Supreme Court has ruled on more than a dozen laws designed to restrict access to abortion. The justices have struck down many of these laws, including limits on the rights of doctors to counsel patients and to use their best medical judgment in deciding fetal age. The court has also upheld laws prohibiting Medicaid funding for abortions for poor women and laws requiring pregnant teenagers to obtain parental consent to abortions. The court's rulings in abortion cases have left many legal issues unsettled. Today's arguments involve some of the most severe restrictions on abortion by any state. The Missouri legislature passed a law in 1986 that included three major provisions. The first announced a state policy that life begins at conception. Another provision barred the use of any state property, including hospitals, for performing abortions or counseling women about abortion. And the third required doctors to perform medically appropriate tests to determine the viability of a fetus when the doctor thought it could be at least 20 weeks old. The Missouri law was challenged by Reproductive Health Services, which provides abortions in St. Louis, and 5 doctors and health professionals who work for the state. They sued Missouri's Attorney General, William Webster, to block enforcement of the law. A federal appellate court struck down every challenged provision of the law, and Webster asked the Supreme Court to reverse that finding. The stakes in this case are reflected by the record number of amicus curiae, or friend of the court briefs, a total of 78, filed by groups on both sides of the abortion issue. Attorney General Webster will argue his own case to the justices. He first outlines the issues before the court.
Mr. Chief Justice, and may it please the court, this case represents a direct appeal that involves a 1986 Missouri statute defining the rights of the unborn and regulating abortion in Missouri. Missouri's appeal involves 3 basic areas for this court's review. The first, the constitutional boundaries on the limitations of public funding. The second, the effect of and the facial constitutionality of legislation declaring that life begins at conception. And third, the ability of a state to require a physician to perform tests and to make and record findings when determining viability. Finally, we've asked this court to reconsider the standard of review to be applied to state abortion regulation. Since 1973, this court has reaffirmed Roe v. Wade's mandate. State and lower federal courts have repeatedly interpreted that mandate, frequently strictly against the states. One result is that the states have effectively been forbidden not only to prohibit abortion, but usually to regulate abortion in any significant way.
The appellate judges upheld the Missouri ban on public funds for abortions, relying on a Supreme Court ruling in 1980 that barred federal funding for abortions. But they struck down the state's prohibition on any abortion in public hospitals, even for women who could afford them. Webster defended this policy.
We would begin with the public funding area, where the Eighth Circuit upheld that portion of Missouri's law which declared unlawful the expenditure of public funds for the purpose of performing or assisting in an abortion. We contend the government is certainly not obligated in and of itself to become an advocate for abortion. This court was very explicit in Mayer when it concluded that a state is not required to show a compelling interest for its policy choice to favor childbirth, normal childbirth, over advocacy of abortion. And it seems to us a convoluted result to suggest that if you can afford an abortion, we have to provide one for you in a public facility, but if you lack the financial capacity to provide an abortion, that the state and other public governmental entities are not obligated to provide those services for you.
Justice John Paul Stevens broke in.
Can I ask you one clarifying question? What is the consequence of a violation of that section? If a doctor should go ahead and do it, is he committing any kind of a misdemeanor or crime?
My opinion is that there is no language in that section which was adopted here which would suggest that it would make it a criminal offense, only that it's directed to those bodies expending the public funds themselves.
Webster turned to the preamble of the Missouri law, declaring the state's policy that life begins at conception.
The district court held that this preamble was in conflict with the essence of Roe. We believe this is clearly wrong. The district court also relied on language in Akron which suggests that a state cannot adopt one theory of life, at least when life begins, for the purpose of justifying its regulation of abortion. We have suggested from the outset in this case that these findings are part of the statutory preamble and do not serve as any substantive right. They impose no substantive responsibility. The statute does not in any way affect a woman's constitutional right to choose abortion over childbirth. The statute does specifically exclude abortion, and the court seems to be attempting here to try and divine what the legislature's motivations might have been with language which we contend has no operative effect. The Eighth Circuit has invalidated an abstract philosophical statement of the legislature because apparently they don't agree with it, and that seems to be the type of direction that we're seeing in a number of the lower courts. We contend this declaration doesn't affect anyone, that it was clearly improperly struck down at the lower court level, and that legislative bodies around this country should be entitled, at least in the non-abortion area, to have a philosophical statement of when they contend life begins.
Webster moved to the provision that requires doctors to perform tests of fetal viability. His argument sparked a lengthy debate with Justice Stevens.
There's also a provision of the statute that was struck down which deals with the requirements to conduct tests to make findings to determine viability. We have said at the outset, under Roe, that Missouri and every other state has an important and legitimate interest in the fetus throughout pregnancy, and even adopting the Roe standard, certainly that interest becomes compelling at viability. This court has said so. We contend the state should be permitted to protect viable unborn children by requiring physicians, in their best medical judgment, to undertake such tests as are necessary to provide findings of gestational age and weight.
The question is whether, if the doctor doesn't think it's necessary, does the statute require him to make the finding on A, weight, and B, lungs?
No.
And on neither?
I don't.
On neither?
Well, I don't believe that it requires an unnecessary test. And to the extent they can determine that a fetus is viable with the first finding, I don't think their ordinary skill would require them to go beyond that. If they've made the determination that at that point the fetus is viable, I don't believe they need to go beyond it.
Say they make the determination that it's not viable.
Then I believe it would be appropriate, given the state's compelling...
The question is whether the statute requires it.
I believe the statute would require them to go forward
with all three tests.
At least with the next test to determine whether or not the fetus is viable. Yes, Your Honor.
How about with the third test?
If the first two tests don't indicate viability, then they would need to, and if there was some indication
Well, the woman appears to be more than 20 weeks into the pregnancy. Does the doctor have to perform the lung test?
Only if in his ordinary skill and care he has
it's not
reason to
necessary.
believe.
The question is whether the statute requires him to do it, even if he doesn't think it's necessary.
I don't believe the statute requires a physician to perform any tests that would be unnecessary. We would finally suggest in this area that if Roe is the standard that is to be applied to the states, and if the dependence is viability is going to be that bright line that states are supposed to depend on, that at a minimum we believe that states should have a right to ensure a reasonable effort to determine viability. And in this area, we're not telling the physician what kind of test to require. We're not even requiring him to use these tests and have them to be determinative of viability. We're merely requiring that a physician, usually a pro-abortion physician, make findings and record them.
Webster backed away from asking the justices to overturn the Roe decision. Charles Freed, a former Solicitor General who spoke for the Reagan administration, did not shy from this position. Chief Justice Rehnquist welcomes him to the podium.
Mr. Freed.
Thank you, Mr. Chief Justice, and may it please the Court. Today, the United States asks this Court to reconsider and overrule its decision in Roe v. Wade. At the outset, I would like to make quite clear how limited that submission is. First, we are not asking the Court to unravel the fabric of unenumerated and privacy rights which this Court has woven in cases like Meyer and Pierce and Moore and Griswold. Rather, we are asking the Court to pull this one thread. And the reason is well stated by this Court in Harris and McRae. Abortion is different. It involves the purposeful termination, as the Court said, of potential life. And I would only add that in the minds of many legislatures who pass abortion regulation, it is not merely potential life, but actual human life. And though we do not believe that the 14th Amendment takes any position on that question, we think it is an utter non sequitur to say that therefore the organized community must also take no position in legislation and may not use such a position as a premise for regulation.
The court announced the right to privacy in the Griswold case in 1965, striking down laws against birth control. Griswold became the basis for the Roe decision on abortion. Justice Anthony Kennedy quizzed Freed about the two cases.
Your position, Mr. Freed, then, is that Griswold versus Connecticut is correct and should be retained?
Exactly. Yes, it is, Your Honor.
Is that because there is a fundamental right involved in that case?
In Griswold against Connecticut, there was a right which was well established in a whole fabric of quite concrete matters, quite concrete. It involved not an abstraction such as the right to control one's body, an abstraction such as the right to be let alone. It involved quite concrete intrusions into the details of marital intimacy. And that was emphasized by the court. There was a great deal of talk about inquiry into the marital bedroom. And I think that's a very different story from what we have here.
Justice Sandra O'Connor asked Freed a basic question.
You say there is no fundamental right to decide whether to have a child or not?
I think that question
right to procreate. Do you deny that the Constitution protects that right?
I would hesitate to formulate the right in such abstract terms, and I think the court, prior to Roe v. Wade, quite prudently also avoided such sweeping generalities. That was the wisdom of Griswold. What is necessary is for the court to return to legislatures an opportunity in some substantial way to express their preference, which the court says they may express, for normal childbirth over abortion. And Roe v. Wade stands as a significant barrier to that.
Thank you, Mr. Freed. Mr. Sussman?
Chief Justice Rehnquist welcomes Frank Sussman, a prominent St. Louis lawyer who argues for reproductive health services. Sussman begins with a swipe at Freed's argument for reversing the Roe decision.
Mr. Chief Justice, and may it please the court, I think the Solicitor General's submission is somewhat disingenuous when he suggests to this court that he does not seek to unravel the whole cloth of procreational rights, but merely to pull a thread. It's always been my personal experience that when I pull a thread, my sleeve falls off. There is no stopping. It is not a thread he is after. It is the full range of procreational rights and choices that constitute the fundamental right that has been recognized by this court. For better or for worse, there no longer exists any bright line between the fundamental right that was established in Griswold and the fundamental right of abortion that was established in Roe. These two rights, because of advances in medicine and science, now overlap. They coalesce and merge, and they are not distinct.
Justice Anthony Kennedy pushed Sussman on the limits of his argument.
Do you agree that the state can forbid abortions to preserve the life of the mother after the fetus, say, 8 months old?
If I understand the question, Justice Kennedy, I think the health rights of the woman always are supreme at any stage of pregnancy, which is basically what...
Suppose the health rights of the mother are not involved. Like, the life or health of the mother is not involved. Can the state prohibit an abortion after the fetus is 8 months old?
Yes, I am willing to recognize the compelling interest granted in Roe of the state in potential fetal life after the point of viability.
But that's a line drawing, isn't it?
Yes, it is. But that is a line that is more easily drawn. I think there are many cogent reasons for picking the point of viability, which is what we have today under Roe.
Sussman tried to educate the justices on the medical aspects of abortion.
30% of pregnancies in this country today terminate in abortion. It is a high rate. It is a rate that sometimes astounds people, but it is a rate that has not changed one whit from the time the Constitution was enacted through the 1800s and through the 1900s. That has always been the rate. It is significantly less than the worldwide rate. Worldwide, 40% of all pregnancies terminate in abortion. Abortion today is the most common surgical procedure in the United States, with the possible exception of contraception. It remains today, as it was in the days of Roe, 17 times safer than childbirth, 100 times safer than appendectomy, a safe procedure, minor surgery.
Sussman and Chief Justice Rehnquist debated the relevance of history to the abortion question.
I suggest that there can be no ordered liberty for women without control over their education, their employment, their health, their childbearing, and their personal aspirations. There does, in fact, exist a deeply rooted tradition that the government steer clear of decisions affecting the bedroom, childbearing, and the doctor-patient relationship as it pertains to these concerns.
There's a deeply rooted tradition, but surely abortion was regulated by the states in the 19th century and in the 20th century.
Yes, but I think it is necessary to go back and examine, as the historical brief does in other works, as to the reasons those regulations were enacted. Similarly, they were not done to protect the fetus. Those were not the purposes. If you look, for example...
If you say there's a deeply rooted tradition of freedom in this area, that suggests that there had been no legislative intervention to me. And that simply is not the fact.
I think we can look to a deeply rooted tradition as opposed to black and white issues as opposed to slavery. And yet we had much legislation. In fact, following this court's opinion in Brown in 1954, almost every southern state without exception passed legislation directly in conflict with that opinion. So the fact that legislation has been enacted does not, in my mind...
Well, I'm not talking about legislation post-Roe against Wade. I'm talking about legislative regulation of abortion in the 19th century and the 20th century before Roe against Wade. You may be right that that is unconstitutional under Roe against Wade, but I don't see how you can argue that there was a deeply rooted tradition of no regulation.
Because I think you have to examine the period before the regulations came into effect. Every state adopted anti-abortion legislation in the 1820s and the 1830s and the 1840s. But before that time, it went without regulation. It was accepted. It was not a crime at common law, as Roe and other works have recognized.
Justice Antonin Scalia turned the debate from history to morality. The court had ruled in the Roe case that a fetus was not a person under the Constitution. Scalia raised this question with Sussman.
I can see deriving a fundamental right from either a long tradition that this is the right to abort has always been protected. I don't see that tradition. But I suppose you could also derive a fundamental right just simply from the text of the Constitution plus the logic of the matter or whatever. How can you derive it that way here without making a determination as to whether the fetus is a human life or not? It's very hard to say it just as a matter of basic principle that it must be a fundamental right unless you make the determination that the organism that is destroyed is not a human life. Can you, as a matter of logic or principle, make that determination otherwise?
I think the basic question, and of course it goes to one of the specific provisions of the statute, as to whether this is a human life or whether human life begins at conception, is not something that is verifiable as a fact. It is a question verifiable only by reliance upon faith. It is a question of labels. Neither side in this issue and debate would ever disagree on the physiological facts. Both sides would agree as to when a heartbeat can first be detected. Both sides would agree as to when brain waves can be first detected. But when you come to try to place the emotional labels on what you call that collection of physiological facts, that's where people part company.
Oh, I agree with you entirely. But what conclusion does that lead you to?
It leads me...
Therefore, there must be a fundamental right on the part of a woman to destroy this thing that we don't know what it is, or rather, that whether there is or isn't is a matter that you vote upon. Since we don't know the answer, people have to make up their minds the best they can.
The conclusion to which it leads me is that when you have an issue that is so divisive and so emotional and so personal and so intimate that it must be left as a fundamental right to the individual to make that choice under her then attendant circumstances, her religious beliefs, her moral beliefs, and in consultation with her physician. The very debate that went on outside this morning, outside this building, and has gone on in various towns and communities across our nation, is the same debate that every woman who becomes pregnant and doesn't wish to be pregnant has with herself. Women do not make these decisions lightly. They agonize over them. And they take what we see out front and what we see in the media, and they personalize it and they go through it themselves. And the very fact that it is so contested is one of those things that makes me believe that it must remain as a fundamental right with the individual, and that the state legislatures have no business invading this decision.
Sussman ended by attacking Missouri's declaration that life begins at conception. He debated the issue with Justice Kennedy.
What troubled me perhaps the most about this section is that if the state is free to adopt a definition of when human life begins, which they have, and they have picked out conception as that time, then clearly there is nothing to prevent a second state from picking birth as when human life begins, and a third state from picking viability, and a fourth state from picking 12 weeks.
Are those first three options ones on which reasonable people could disagree?
Yes, but I think even on the fourth option, that let's say state number 4...
Do you have any authority in our jurisprudence other than the cases following from Roe versus Wade that tells a state it cannot adopt a proposition that reasonable people agree with?
No, but I think the problem here is that the adoption...
So this is unique to Roe?
I think this is somewhat unique. I think the adoption of Section 205, first of all, it clearly is not necessary in order to regulate abortion or to grant property rights or tort rights to fetuses. It is not necessary to have that proposition to do so. Other states have clearly done so without making these types of purported legislative findings. And therefore, if it is totally unnecessary to do that, which we maintain that it is, then what they really have done is to adopt a particular religious belief about which there is clearly no consensus and placed it into the law of the land of the state of Missouri.
The Supreme Court decided the Webster case on July 3, 1989. Partisans on both sides had hoped for a clear decision on state regulation of abortion. They were all disappointed, as the justices split into 8 separate factions on the issues raised by the Missouri law. The court's divisions reflected the public debate over abortion. A clear majority supports the right to abortion, but many are willing to accept some restrictions on this right. The real question in Webster was whether the court would overturn the Roe decision. Speaking only for 2 colleagues, Chief Justice Rehnquist, who had dissented in Roe, wrote with obvious regret that the Webster case affords us no occasion to revisit the holding of Roe. But Rehnquist spoke for a majority of 5 in upholding the Missouri ban on counseling for abortion and the requirement that doctors perform tests for fetal viability. The court also agreed that the Missouri policy that life begins at conception had no legal effect. Justice Antonin Scalia, who fiercely opposes abortion, denounced the court for refusing to overturn the Roe decision. He aimed his opinion at Justice Sandra O'Connor, who wrote that Webster presented no need to decide whether Roe was correct. Scalia replied that O'Connor's position cannot be taken seriously. 3 years later, O'Connor responded to Scalia by writing that Roe should be retained and once again reaffirmed. Justice Harry Blackmun, the author of the Roe decision, wrote for the dissenters in Webster. He agreed with Scalia that the court had silently overturned the Roe decision. Blackmun said that Rehnquist had given state lawmakers winks and nods and knowing glances that the court would uphold more restrictions on abortion rights. Blackmun concluded that a chill wind blows over the right of pregnant women to control their destiny. The outcome of the Webster case pleased very few people other than William Webster. Both sides of the abortion issue renewed their efforts, and the Supreme Court waited for the next major challenge to abortion rights. It came in 1992 in the case of Planned Parenthood versus Casey. Arguments on Abortion is a production of the Earl Warren Bill of Rights Project of the University of California, San Diego.
Okay, so it's 1:31. Do a quick station break. You're watching what's going on with your host, Hugo Fernandez, myself, here in LaGuardia, WLGR. And today's show is about the Supreme Court case which you just heard, Webster versus Reproductive Health Services. And my guests today are Dr. Vera Albrecht and Dr. Sharon Proctor of the Humanities Philosophy Program, who both teach the philosophy of law. So, doctors, where do we begin? Who would like to begin?
I just want to point out that it's very well chosen. Am I muted still?
No, you're on.
Okay. Because just today, the New York Times has it in the live updates that the Supreme Court is decided to hear a case challenging Roe v. Wade. So this is very close to this case, which was also intended not only to be about this case that is at stake, but to challenge the whole Roe v. Wade case.
I was just looking this up on my phone. It's the case that's coming up is Dobbs Jackson Women's Health Organization. It's about Mississippi. So unsurprisingly. I thought that was really interesting timing as well. And it's especially I thought a lot of the cases talked about over the course of this program, right? Have the issues I think have been clear cut. There's been much more opportunities I think to philosophically dissect. I think here. I found this case a bit more difficult to prep about what really to add in. I'm not sure if you had a similar kind of experience about this one.
Yes, absolutely. Plus, so once I read the New York Times article, all of a sudden started to mix it up because there are similarities. I mean, And at one point I was thinking, wait a minute, am I talking about thinking about talking to myself about the new case or the Webster case here? Again, in the end, I think it's nice because nobody was happy with Webster except for Webster himself. Because those people who were with him, they really were hoping to outlaw Roe v. Wade, make it possible to completely outlaw abortions. At least in some states that decided that they wanted to do this, and it did not succeed. But at the same time, those people. I mean, when the case won, it wasn't much won, not as much as they had hoped. But of course, it opened the doors, which we have seen in many other cases afterwards, to impose restrictions and impose serious restrictions that some people have claimed. Well, this comes very close to overturning Roe v. Wade because the restrictions are so serious.
I was thinking about another. Sorry, there.
No, go ahead.
There was another article about abortion in the New York Times. I think this was maybe a week ago that was talking about it in terms of the pandemic and how a lot of the laws that people have been making this chipping away are ostensibly about women's health. And this argument was you saw this when he was giving some of the medical facts about the safety of having an abortion procedure, right? Is that there's a lot of times these laws are supposed to be about the health of the woman, and truly that's just does not back up the medical science behind the safety of this procedure.
Well, I looked up some of the statistics, and one of the things I found is that abortion rates have dropped since this case. I think it was saying depending on which you're looking at, the numbers are for 1,000 women, about 11 point something. Abortions are happening. So that's one thing. As black men at the end, the chill wind remark that he made, and the winks and nods. It's had an effect. Well, I found interesting about this case, though. One of the many things, of course, this issue of when does life begin, which is this issue of does it begin at conception? Is it 12 months? I forgot the four. Is it viability
or birth? The other one.
Or birth. Obviously, birth is number two. But the fact that it also factionalized the court itself. Eight kind of. And I was looking at the. I did not read. I don't know if you know. Shannon's always the good study. Who reads all decisions. But so you've got. O'Connor and Scalia agreeing with Rehnquist who had majority decisions in part. But even Scalia is not happy with the court in this particular waiver. And then you had the three dissenters who now I'm thinking Marshall, Kennedy, and I forgot who the other one was. I had it here. My Ove, it's Blackman. So Brennan, Marshall, and Stevens. No. Brennan, Marshall, Blackman, and Stevens. So this case only got through with one. Or maybe I'm looking at this chart wrong.
Oh, it was narrowly decided. I think it was.
It was four. Brennan, Marshall, Stevens, and Blackman all against it. Well.
I think that really speaks to what Sussman was arguing about how much contention there is around this issue about there's just this absolute lack of consensus, and then that brings in questions that are maybe beyond some of my knowledge of how the court tends to handle, like how much freedom does the state have to make laws when there is this much contention around some of those central definitions. I think that could be something interesting to look into for those who are really interested in this case. Further research, right? Like how do state legislatures work on these areas which there is not scientific, medical, or even just citizen-wide consensus?
Well, you have two philosophers in the room, right? So here is that question. is life? And I guess in this case we're talking about what is human life. And Shannon's like, I'm not going to take that. I'm not going to answer that question.
No, of course, that's the question to ask here. 100%. I simply myself find that to be an unanswerable question unless we start getting into a linguistics game, where I simply want to define the term in such a way that it then supports the moral or otherwise philosophical view that I have about these issues. Typically, maybe a moral or religious view I have about these issues. I have never wanted to cast my position in the abortion debate around the answer to that question. I think it is a question more of a balancing of rights. And I think it's also a question about fairness between men and women in terms of what the law is allowed to do. Vera, why don't you answer that for us?
I'm glad that kind of even the area. I don't want to get into this because I think it's a little beside the point if you ask the question, what is life? I mean, that you say life. I mean, what is the distinction then between human life and any other mammal life, which are routinely eaten by humans, even after they're born. So I know that this is a very unpopular question, but I think it asks the wrong question for this. Because we're talking precisely about rights, and I'm with you. Is there there's a balance of rights. The right of maybe it is a human being, right? But I mean, it's not that we give just outright rights just because someone is called human. And besides, some humans they are being deprived of rights, especially in these southern states that execute people who are already way after. So I think this is the question of when does life begin, or when does human life begin is kind of beside the point. And I think even the question of personhood obscures a lot of issues, which is of course one that wasn't even asked here. Sorry. Go ahead.
My bad. I normally do better when I can see your face. Sorry about that. Well, I don't know if I want to use a language of beyond the point, or not the point, but even viability. I would avoid making the viability argument simply because viability of a fetus is a technological question, right? This has to do with what sorts of devices we have, and I think that I'm at least not particularly optimistic about putting women's right to have an abortion into the hands of the creators of new technologies, unless there is some sort of technology that could allow for a fetus to survive with extremely minimal impact on what we see right already. I'm getting well beyond what I can even imagine. I think that right. Personhood, life, viability, these are all extremely interesting philosophical questions. I don't think from a philosophy of law perspective, any of them are the smart way to go if you are trying to keep abortion accessible to women.
So wrong question. And because I was thinking about this too, which the question that was asked, I think was Kennedy, who was asking about 8 months, and what about 8 months? Because I guess at that time that was considered a safe time. Now we have folks who, my neighbor's kids, the twins. I think they were born possibly in the sixth month, and there were complications as a result. The little girl is congenitally blind, or at least legally blind, but the little boy has done well. But so if we start talking about science, the thing for me, it brings up Barbara Kruger. So I'm here going to bring up an artist, feminist artist, kind of famous for putting language with images. And one of the postcards I bought that she of her work is my body is your battleground. And so I guess the question is, why are all of these men in positions of power so caught up with the notion of telling women how they are going to, how they're going to behave with their bodies. Why can't we? Why is this something we can't shake? I know there are a lot of women in the pro-life movement still.
I just want to, pick up on something. Of course, I don't really want to go there, but just put it out for entertainment. Technology. If there was technology that allowing to have that viable fetus to be placed into a male who can then carry out pregnancy, right? So then you can say, that's what people want. Let's just give these fetuses up for placement. But of course that's just as much not feasible, and I don't really want to entertain this as a real argument. But I think it ends up to be a question not of the fetus's right, but the question of the woman's right.
I think there's a real political history to this as well. I believe this came up maybe in our first show together. Was some of the history of this has to do with the Southern strategy and getting people to move away from Democrats. So certainly we could look at, let's say, the history of the oppression of women in the Western world. Of course, there are many people who have written extensively about the connection between limits on abortion, and sexism, patriarchy. But I also think that there is some more pragmatic decisions that were made politically to get people. This is a wedge issue. This is an issue that makes people change affiliation, right? And it is not a significant political issue before modern history. This was as Sussman talks about. This was something that gone on since the dawn of time. If I may be so bold, right? Or the dawn of humanity. This has occurred. And it is much more contemporary that it has become a legal political issue.
In the legal and political issue, I just want to you're right. It's been an issue since the dawn of time, and maybe most famously with Oedipus, who was supposed to be aborted after birth. That was not unusual. I mean, history shows that a lot of newborns were discarded. And this may not be a nice or pretty situation. Later on, a lot of abortions were performed illegally, which posed great risks of health to women. So what Sussman pointed out is the safety of these procedures is of course one of access to safe abortions. Where once people don't have access to safe abortions, you will find a lot more injuries as a result of illegal abortions. And of course a matter of social status because wealthy people have always found ways to either get a safe abortion, travel to a state that offers a safe abortion, or maybe travel to a different country that offers a safe abortion, as opposed to not having the choice to do all this. So this is ultimately also a social issue because it provides abortion for women, for poor women.
Yes, for women who can't afford to travel. Yeah. And by the way, we moved into the last hour, and Dr. Riccio is not with us today because she's actually taking care of her health. All right. So we have one question from our friend Fuzzy Dancer 278, who's saying who's asking, do we want to become famous? And has some little tiny URL you to go to. So I don't think that's the question want to handle either. Interesting. I'm getting. I'm pretty busy right now. So. It was interesting because when Sussman was relating it to actually when he was talking about board versus Brown education, when that passage suddenly we had all the states coming up with these things, and when they were referring to the 19th century around issues of slavery before in 1840, I started thinking about as Dr. Proctor's saying here, when did this start becoming such an issue? And I wonder if it. I was trying to think, is it an issue as a result of the Great Awakening and this increase in American interest in religion? But you're saying it's not. It's a political one. And it's basically just mobilizing. Like we've seen now how the right is mobilized. Faith groups in this political battle on a wedge issue, which is abortion. But I was thinking. Now here's a case that could reverse Roe v. Wade, the Mississippi case. And the consequences would be Roe v. Wade, for folks that really understand the importance of Roe v. Wade, it's about the federal mandate that abortion is legal in everything. No state can pass a law preventing legal abortion. Right? So if Roe v. Wade is reversed, we could expect that in states that are they blue or red? I can't remember which color.
On the
red state. Yeah.
This would take
governors, Republican controlled senates or assemblies or whatever houses. We could expect. And when you look at that chart. That after the election 2020 it's going to make it pretty tough for folks.
I think that this is where we get. And I believe it was Ginsburg who really talked about this a lot before, not just before passing, but that she never thought that Roe was the right way to achieve abortion. And this is where the come up about will the federal government pass a law?
Legislative.
Probably. Otherwise, it seems as if Roe was overturned. Then state legislatures are going to pass laws that have them absolutely ready to go. This would be as soon as they could get people back, into vote. And then I think the question becomes what kind of pushback? Is there political pushback? I think a lot of people, especially talking about looking at class, wealth, and access here, don't take this issue to be serious. I think a lot of people thought this was a settled issue, legally a settled issue. And it's absolutely.
And so for a lot of people, especially the southern states, for many people, this was the sole issue. That was an election issue. I mean, a lot of people voted just solely on the grounds of whether someone is for or against abortion. And as we see, the way the Supreme Court has been stacked now, which makes it a lot more likely for Roe v. Wade to be overturned. And the whole political goal was to design or make the Supreme Court so that Roe v. Wade can be overturned. And it's been a highly political issue. And it's interesting because I don't think this was such a political issue. Maybe even at the time of Webster. I think it became a lot more controversial now than it was even back in 1989. But that's just me speaking because I said 1989 isn't that long ago, but depends on who you're talking to.
I just wonder. Oh, sorry. Go ahead, Dr. Proctor.
I took the last one. You get this one.
Well, I'm just saying that would it be enough to pass a law because then a law could be challenged as being unconstitutional? Isn't it? Are we really looking at having a constitutional, amendment that makes it legal, which is probably almost impossible to pass.
This gets into issues about states that are a little bit beyond my deep understanding. And so there might be questions about what the federal law would have to look like to not violate states' rights, right? Certainly a constitutional amendment would get rid of the problem of states' rights, but then you have to get through passing a constitutional amendment.
Right.
One other little piece I just wanted to throw in here is it's also not just the case that red states, like if you're someone who lived in certain red states that would pass laws banning all abortions, they also have laws ready to go that would make it illegal to go to another state to get an abortion. So you couldn't travel to New York City and then come home or you risk being arrested.
You have to move.
That's true. Yeah, that's true.
You have to go into exile. Yeah. We're running out of time. Any last thoughts or last things you want to say about this one?
Pay attention if you're listening.
Pay attention. And I want to say on the Mississippi case, let's keep our fingers crossed.
I don't know if fingers are enough. All right, well, we got save a little time for the music. So I just wanted to say thank you to you both, doctors, doctors. And we're at the end of our season here practically for the spring. And I guess we'll talk off camera about whether we're going to continue through the summer or whether we will hold off until the fall, because we still got a few more cases to go through this particular edition of the text. And then we'll see where we go through from there. But I want to thank you both for being on the show, for doing your homework, for for coming in here with your own unique ideas and not somebody else's, which we pray that our students can take the example of.
Thank you, Hugo and Chris and Jamie.
Yeah, thank you all.
Thank you all
for making this possible.
Yeah, she'll be watching the replay later. So we hope everything went well with her. And I just want to say you've been watching What's Going On. I'm your host, Hugo Fernandez, here on LaGuardia Web Radio, WLGR. And this is one more episode in our continuing series on May It Please the Court, arguments on abortion, recordings from the Supreme Court of the United States concerning reproductive rights. And we're going to go out as we came in. Oh, my guests today, of course, Drs. Vera Albrecht and Dr. Shannon Proctor of the Humanities Philosophy Program, who teach the philosophy of law. And if you get a little taste of what their classrooms must be like on a day-to-day basis when these questions come up. But thanks for listening. And Mr. Pope, take us out as we began. Thank you.